Welcome back to The Explainer. Today, we're diving into our source material to unpack a seriously fascinating, high-stakes legal showdown. We're going to look at how two neighboring, highly developed legal systems, England and Germany, tackle the exact same problem in completely different ways. And the core of that problem? Well, it's this. When the state actually makes a mistake, who ultimately pays the price?
Okay, let's dive into this, because the stakes here, they aren't just theoretical. We're talking life and death. Imagine a scenario where the authorities are explicitly warned about severe, imminent threat to your safety, but they just fail to act. If the absolute worst happens, can you hold the police financially accountable for that negligence? It sounds like it should be a simple yes or no, right? But as you'll see through the incredibly tragic real-world case of the Osmond family, the answer exposes a massive philosophical divide in how a country views the very duties of its own government.
So, here's our roadmap for this explainer. First, the dilemma. Second, the English approach. Third, the German approach. Fourth, limiting liability. And finally, we'll wrap up with the human rights curveball.
All right, Section 1, the dilemma when the state causes harm. Now, the absolute catalyst for this debate is the devastating Osmond case. Here's what happened. A teacher developed a really dangerous, escalating obsession with a male pupil. The police knew about the threat, but they failed to act, which tragically resulted in the father's murder and the boy's severe injury. And yet, when the family sued the police for negligence, the English courts shockingly struck out the action before it even went to a full trial. Now, you're probably wondering, why on earth would the court dismiss such a severe case? Well, it brings us to the ultimate dilemma. You see, in every legal system, there is this brutal tension between two opposing forces. On one side, you have the fundamental right of an individual to seek compensation, obviously. But on the other side, you have the public interest. The government operates with scarce, limited resources. Think about it. If the police or social services can just be constantly sued for every single mistake or failure to act, they might literally go bankrupt. Or they might become so overly defensive that they just stop doing their jobs effectively. Basically, how a country balances these two competing forces completely defines its approach to state liability.
Which brings us to Section 2, the English approach, public policy as a shield. Over time, the English legal system built up this massive shield to protect its public bodies, and it's heavily based on the rule of law. Now, on the surface, this sounds highly democratic. In theory, English law doesn't formally distinguish between public law and private law. There's no special, separate system of public law torts or civil wrongs. A government department is judged by the exact same rules of negligence that you or I would be. But treating a public authority like a private citizen gets incredibly messy when that authority is doing things literally no private citizen ever does. Like, running emergency services. Let's move to and see how this builds across recent history. This timeline perfectly maps the English court's really volatile relationship with public liability. Back in the 1970s, liability was aggressively expanding, peaking around 1977 with a pretty broad test that made it relatively easy to sue local authorities. But then, panic set in. The courts genuinely feared they had opened the floodgates. So by 1990, we see this sharp retreat. The courts deliberately shifted gears to protect public authorities from just being overwhelmed by an avalanche of lawsuits. And that retreat resulted in the modern legal standard we use today, known as the Caparo test. For a public body to actually be held liable for negligence in England, a plaintiff has to prove three things. 1, the damage was foreseeable. 2, there was sufficient proximity between the parties. And 3, here's the kicker, that it is fair, just, and reasonable to impose a duty of care. That third step, that is the magic trapdoor. English courts heavily lean on this fair, just, and reasonable standard as a policy shield. If a judge decides that a lawsuit would drain police resources or cause so-called defensive policing, they just declare it's not fair, just, and reasonable to hold them liable, and boom, the case is thrown out. Furthermore, English law views inaction in a very specific, kinda counterintuitive way. There is no general liability for omissions. Basically, you don't have a legal duty to save a drowning stranger, even if you're an Olympic swimmer. And because public bodies are treated just like private citizens, this exact same rule applies to them too, which means emergency services actually have no common law duty to respond to your call for help. Crazy, right? Unless they've specifically assumed responsibility for you or exerted some sort of special control over the situation, they literally cannot be sued simply for failing to show up. Let's cross the channel for Section 3, the German approach, state liability and sovereign acts. So we're leaving the English system behind for a minute. Germany has a distinctly different legal architecture, one that strictly separates private law from public law.
The baseline in Germany is Section 839 of the German Civil Code, or the BGB. This rule explicitly states that if an official negligently breaches a duty they owe to a citizen, that individual official is personally liable for the damages. Now, originally, back in 1900, the idea was that the specific human who messed up is the one who pays out of their own pocket. But let's be real, squeezing millions in damages out of a random middle-class civil servant is not going to get a grieving family the compensation they need. Plus, it's absolutely terrible for the morale of government workers.
And this brilliantly illustrates how modern Germany solved that exact problem. Notice this shift in the framework. In 1949, Article 34 of the German Constitution stepped in to fix that original rule. It says that when an official is performing a sovereign act, so a public duty like policing or building inspections, the liability instantly shifts from the individual official directly onto the state itself. The government just assumes the responsibility. This is a super powerful, direct form of state liability. It guarantees the victim has a solvent defendant, an entity with actual deep pockets to pay out, without entirely ruining the life of the individual public worker.
Moving on to Section 4, limiting liability, a stark contrast in legal philosophy. So clearly we have two very different setups here. But look, both systems know they can't just write a blank check to every single citizen who gets wronged. They both absolutely need to keep the floodgates of litigation closed to protect the public purse. But they rely on completely opposite philosophies to do it. Let's look at how they handle government discretion, basically the power of an authority to choose how it spends its time and money. In England, the law is terrified of defensive administration. They often declare discretionary decisions to be completely non-judiciable. That means the courts flat out refuse to even look at them, treating them as totally off-limits to judicial review. Meanwhile, Germany takes a totally different stance. They believe that even if an official has discretion, an erroneous use of that discretion is fully reviewable by the courts. The German system basically doesn't believe in granting the state an unreviewable safe space.
Now, that doesn't mean Germany just pays out everyone. They do have a primary limitation tool to protect state funds, and it's called the subsidiarity clause. This rule dictates that the state is not liable for negligence if the victim can claim the exact same damages from somebody else. The underlying philosophy here is to force citizens to look for compensation elsewhere first, making the state a defendant of last resort. But, and this is a big but, it is definitely worth noting that German courts have actively whittled this rule down over the years. They actually bypass it quite often just to ensure equal treatment under the law.
Now, what's really interesting about this comparison is how these two countries view a victim's private insurance when it comes to state liability. Think about it. If your house burns down because the fire department totally messed up, but you have private home insurance, what happens? In England, courts have sometimes used the fact that a victim has insurance as a public policy justification to just deny public liability entirely. Their logic? The victim is covered anyway, so why drain public funds? Germany firmly rejects this. Under German law, your private insurance is viewed as mere interim financing. The state is absolutely not allowed to use your personal prudence, the fact that you were responsible enough to buy insurance, as some sort of get-out-of-jail-free card. The state still has to pay the insurer back.
Finally, let's look at Section 5, the human rights curveball. The ECHR disrupts tradition.
We need to bring our narrative full circle, right back to that tragic Osman case we discussed at the very beginning. Remember, the English courts threw out the Osman family's case against the police, citing public policy. Well, the family didn't stop there. They took their case all the way to the European Court of Human Rights, or the ECHR. And in a massive landmark ruling, the ECHR declared that the English court's approach actually violated Article 6, Paragraph 1 of the European Convention on Human Rights, which is the right to a fair trial. The ECHR basically said you cannot use public policy as this blanket immunity shield to block victims from even presenting their case in court. A fair hearing has to weigh the actual circumstances of the specific tragedy. You can't just automatically dismiss it to protect police resources.
I cannot overstate this. This ruling sent an absolute shockwave through the English judiciary. They had relied on these policy defenses for decades to manage their dockets and protect the state budget. The sheer gravity of this disruption is captured perfectly by Lord Hoffman, who warned of, quote, fears that the entire English jurisprudence on the liability of public authorities for failure to deliver public services is at stake, end quote. Literally, the traditional English defenses against state liability were suddenly highly vulnerable to European human rights standards. It forced a massive legal reckoning.
So, let's zoom out. England built a system that is fundamentally terrified of draining the public purse, using policy to shield the state. Germany, on the other hand, built a system holding the state directly accountable, believing that judicial review is the ultimate protector. So the crucial point is this. Ask yourself, which system actually strikes for right balance? Should a government prioritize protecting its public resources so it can serve the many? Or must it guarantee individual compensation when it utterly fails the few? It's a really heavy question, and honestly, the answer fundamentally defines the society we live in. Thanks so much for joining me on this journey through the source material, and I'll see you in the next explainer.